What will John Roberts do, has been the question among court watchers in recent years, one asked with increasing frequency in the months since former Justice Anthony Kennedy was replaced by Justice Brett Kavanaugh, effectively making 64-year-old Roberts the new swing vote on the court. With the spate of legislation that bans abortion almost entirely permitting it only to save the life of the mother in Alabama, or before the 6th week of pregnancy in the others, the question has taken on new urgency. What will John Roberts do, and when will he do it? Ever since Roe v. Wade established abortion as a constitutional right in 1973, those who disagree with the decision have been strategizing to overturn it. In what constitutional expert Linda Greenhouse has called a long game, opponents have waited for an amenable court, and the addition of Brett Kavanaugh creates the first true conservative majority in 50 years. As an ideological minority, conservative justices have spent the decades effectively whittling away the broad protections of Roe by allowing states to add restrictions such as waiting periods, mandatory counseling, and pre-procedure sonograms. As a majority, might they go one dramatic step further and nullify Roe? The parade of bills headed their way. Laws that are clearly and deliberately unconstitutional under Roe are an attempt to pave the way for such a reversal. Justices Ginsburg, Kagan, Sotomayor, and Breyer can be expected to uphold Roe, while Justices Thomas, Alito, Gorsuch, and Kavanaugh have indicated in writings and public statements that they would be inclined to reverse it. Which is why the spotlight is on Roberts and the conflicting ideological threads of his legal career. The only one who truly knows Roberts's mind is the man himself, but court observers are watching closely, testing assumptions they have come to hold over the years, and wondering how those might play out in this new normal. Roberts, a practicing Catholic whose wife, Jane, has been active in the anti-abortion group Feminists for Life, is widely assumed to be personally opposed to abortion. As what Newsweek called a rock-ribbed Republican, he served in both the Bush and Reagan administrations. As Deputy Solicitor General in 1990, he authored a brief saying the 7-2 Roe decision was wrongly decided and should be overruled, and that a right to abortion finds no support in the text, structure, or history of the Constitution. In a memorable exchange with then Pennsylvania Senator Arlen Specter, who was a pro-choice Republican moderate back when such a thing was more possible, Roberts said, "It is a jolt to the legal system when you override a precedent, because precedent plays an important role in promoting stability and even-handedness. It is not enough that you may think the prior decision was wrongly decided." Specter went on to ask whether Roe was in fact a super-duper precedent because its core reasoning had been upheld in the 1992 opinion in Planned Parenthood v. Casey. In that case, Roe had seemed in danger of being overturned, but instead the court held that state regulations of abortion are unconstitutional if they pose an undue burden for patients. Roberts refused to agree with Specter's super-duper language, but did affirm his commitment to stare decisis, Latin for to stand by things, which is the legal term for respecting precedent. He added, however, that sometimes there is reason to overturn previous decisions, including when precedent has been eroded by subsequent developments in the law. In his votes on abortion cases over the years, he has often sided with states seeking to restrict abortion rights. Notably, he voted with the majority to uphold the federal partial birth abortion ban in 2007, and to overturn a California law which regulated anti-abortion crisis centers last year. In between, he voted with the minority in Whole Woman's Health v. Hellerstedt in 2016, in which the majority ruled that a Texas law setting stringent requirements for abortion providers requiring that doctors who perform abortions have admitting privileges within 30 miles of their clinic and that abortion clinics meet the same standards as ambulatory surgical centers posed an undue burden. And yet, in keeping with his belief in stare decisis, he then voted with the majority last year in agreeing to put on hold a Louisiana law that was essentially a copy of the Texas law he voted to uphold in Hellerstedt. That vote, however, was simply to keep the law from going into effect while giving the justices more time to consider whether they would agree to hear it. "He has spent a lot of time talking about court legitimacy," said Sarah Banush, a professor of political science at the University of Wisconsin. She cites his vote to uphold Obamacare several years ago as an attempt to keep the court from being seen as having a partisan agenda. He demonstrated that there were concerns about the court as an institution that might sometimes trump his sincere policy wishes, she said in an interview with NewsPulse News. New York University law professor Melissa Murray, who specializes in constitutional law and reproductive rights, agreed with Benesch. I think Chief Justice Roberts is very different from who Associate Justice Roberts would have been. Were he not Chief Justice, he would be more like a Justice Alito. But he feels the responsibility of this role very deeply. Which does not mean Roberts has never voted to reverse standing precedent. But he has done so incrementally. Court observers have been finding a two-step process in those reversals, specifically in the areas of labor rights and voting rights. In both realms, the Supreme Court let a prior ruling stand, but also allowed states to enact laws that effectively gutted those prior rulings, what Yale law professor Reva Stein has called a stealth overruling. Murray, noting that the first blows against Roe have been landing for years, predicts that the knockout punch would be unlikely to come before the next presidential election. I don't think this is a court that would overturn Roe v. Wade with a full stop, she said. Roberts certainly wouldn't do that in an election year. The justices rarely give reasons for not accepting cases, and it is possible that the push to hear the case came from the right, among justices who wanted to uphold the law, Blackmun says, or even use the case as an excuse to overturn Roe. But it is also possible the push came from the liberal justices seeking to force the court to take it, to see if they are serious about overturning Roe. It's a weird dance between the conservatives and the liberals, Blackmun said. There is absolutely no world in which the Supreme Court takes that case and upholds it unless they are willing to throw out all existing precedent on privacy, says Benesch of the Alabama law, which only permits abortion if the health of the mother is in serious danger, and which exposes doctors to 99-year jail terms for performing an abortion. And once it is teed whether by the Louisiana law that he voted to stay, or a separate Indiana law that prohibits abortion in cases of a fetal diagnosis of Down syndrome, or nearly a dozen other laws potentially making their way to the docket for the next session, it will likely come down to Roberts. Will he do as he did with the Affordable Care Act and vote against his ideological interests in favor of protecting the nonpartisan image of the court? Or will he do as he did last year, joining the 4 conservative justices in voting to overturn a 1977 decision requiring workers to pay dues, or agency fees, to unions even if they aren't members? And will he remain the deciding vote long enough for any of this strategizing to matter? We could have another vacancy before any of these cases are decided, Blackmun said. That's entirely possible.